filing fees goes up. And now each H-1B application, we have to pay $600 for political asylum. Emily, our guys are not applying for political asylum. What are you speaking?
Well,
You have, I mean, you have any sense? My guys are applying for H-1B and you're telling my guys have to pay $600 for every H-1B application?
yep, and I-140.
What? What does that have to do with political asylum? I'm sorry. No. They are not applying for political asylum. They are just applying for H-1B. And I-140 also, that we have to pay the $600 political asylum fees. But our
Yes.
guys are not applying political asylum.
Well, it's the asylum program fee, so it's going to cover the cost of our government's response to the asylum, I guess, budget needs. So yeah.
Okay, explain me about the fees, like Emily. What's going on?
All right, so we have the advanced publishing of the final regulation. So the actual regulation will be published tomorrow, but we get an advanced copy of it so we can see that. Number one, so it pretty much increases most filing fees for employment-based immigration. Number two, it doesn't take effect until April 1st. So that means this regulation is the one that talked about increasing the lottery registration fee from $10 to $215, but it does not take effect until April 1st. So that means, yes, they are increasing that fee, but it will not be effective for this lottery that's happening in March. It's going to be effective next year when the lottery happens. So that's important to know.
Emily, what does that mean? That are we going with the new lottery system? Are we going with the old lottery system that promotes the fraud more?
So I think we're going to go with a new system, but with the old fee. The new system, we're expecting a final regulation to be published soon that kind of carves out the changes to the lottery from the big H-1B regulation that was proposed last year. So it does appear that they're still planning to go with this new version of the lottery, particularly because they had the stakeholder engagement last week with the new registration system, the new platform that allows employers and attorneys to collaborate for some unknown reason. So we are pretty sure that the registration process will change. So it's the new lottery system where each person only gets their name in the hat once, regardless of how many job offers they have. But the filing fee will still only be $10 because this regulation doesn't take effect until after the window.
Okay, so and then some other news for those people who are filing EAD and AP applications, though. The filing fees for especially those people who are in adjustment of status, there was no filing fees for EAD and advance parole. Now, every time they file an EAD and advance parole starting from April 1st of 2024, they have to pay an additional fees for the EAD and advance parole. That's a very bad news. I hope so they will continue giving the 5 years EAD and advance parole. They also increase the fees for the adjustment of status. But what is ridiculous is to have the fees increased, to have the H-1B, the people who file for the H-1B application, the employers who file the H-1B application have to pay $600 to cover the cost of the political asylum, even though these people have never dream of applying political asylum, not eligible for political asylum, but it's just because these people have money or they can afford it, they're charging it on this. This is ridiculous, though.
Yeah, so one of the things they took into account from the comments they received was that this is hurting small businesses that might be using these different visa programs. So they did decide that that $600 fee that has to be paid for every I-129 and every I-140 does not have to be paid for nonprofit organizations. And if your company has 25 or fewer full-time employees, it's cut in half to only $300 for every I-129 and every I-140 filed by that company.
So is it only, do we know? I know it just came like 10 minutes ago. We're scrambling with this 586 pages of the regulations that are going to be published tomorrow. Do we know, Emily, that what this H-1B, this $600 or $300 is every time we file a H-1B or only first time H-1B filings? Or
I
is
don't
it
think it specifies. I'm guessing it's going to be every time because they definitely did not. It just says, yeah, paid by employers who file either a form I-129 or I-140. So my guess is everyone. So any first extension, second extension, amendment.
That's a lot of fees.
Yeah.
That's more than the H-1B fees we pay right now. That's a lot more than H-1B fees. For the, I mean, we have other two fees, but for amendments and other things, the fees is very less than we are adding up $600 for each of the applications. That's a lot of money to be spent by the employers on this one. Anything else, Emily, on this one?
Yeah, there's another section where they create some procedural changes to address some issues with fee exemptions and discounts. So one of their changes is they're saying that if USCIS accepts your filing, but it has the wrong fee amount, rather than telling you, hey, the fee is wrong, please send us the right fee, they're just going to deny it. That doesn't seem quite right. And then if they actually approved it before they realized the fee was not correct, they're going to revoke the approval.
Instead of giving a chance to pay the money.
Yeah, exactly. So we know USCIS makes mistakes all the time. We know they've approved 485s when they shouldn't have because the priority date was not current. Now you're saying if they accidentally accept my filing fee for my 485 and I got the fee wrong, and they 10 years later approve my 485 when my final action date becomes current, they're just going to go back and rescind my green card because they made a mistake and accepted the wrong fee instead of just asking for the correct fee to be paid. That does not seem fair at all. And I don't know, I don't recall that being in the proposed rule. They're just throwing it out there in kind of the preamble of this final rule.
Okay, we'll come back on this one and discuss a little bit more extensively on the filing fees. Let's go to the next topic. Oh, now we have 1.4 million people granted non-immigrant visas to United States, Emily. From India. India is one of the top people who have been given non-immigrant visas. I think so it's about 10% of the entire visas given in the entire world comes from India. Now, there are some discounts because for European nations, they don't have to get to B2 visa to come into the United States, which most of the visas that probably were granted, Emily, or at least good number of the visas that were granted were visiting visas, B1 or B2, for the Indian nationals. What do you anticipate, especially when we see a lot more students coming into the United States? The percentage of people who are getting the H-1B through the lottery has increased for the Indians. The number of people who are coming on L1 is going up. What do you see the future for the non-immigrant people who are in the United States? Who most probably, if they are an H-1B, they want to get the green card, or if they are F1, they want to get the H-1B. What do you anticipate the problems for these individuals, Emily?
Well, I think the biggest problem is going to be the lack of green card availability that's caused by the 7% per country limit. If we have, 1.4 million people coming into the US, and again, you mentioned a lot of those are B2, but we're talking F1 students, they're going to be putting their name in for the lottery at some point. The lottery is already a mess. In this proposed or final regulation about the fee, USCIS had suggested that they're expecting 400,000 registrations in this coming year. That's how they calculated how much money they might make off from this system. So even if they're implementing the new registration process where each person only gets one, if you're talking about 400,000 registrations for 85,000 slots, I mean, the chances of being selected are so low. So that's going to be the first hurdle. And then people are going to run out of OPT time, run out of STEM OPT time. Then they're going to have to go to these day one CPT schools to try to stick it out for another year, or try for an O1, or try for an EB1. So that's just on the student visa side. And then all of the H-1Bs are stuck in the backlog already. EB2 and EB3 are terribly backlogged. EB1 is, 2020, but I would expect that might get worse. It's not going to get better, that's for sure, because more and more people are filing an EB1 now as they've eased up the qualifying criteria for the EB1A category and opened it up more for STEM jobs. So we have that problem. And so, right now only EB5 is the only option that's current for India. That's not going to last forever once those green cards start being issued. So it's just going to be gridlock everywhere. Continuing to extend your H-1B every 3 years, with no end in sight, no ability to ever vote in an election. You're paying all these taxes, but not able to take advantage of any of the services that those taxes to provide. So it's a very grim future, I think.
Okay, 1 second. Let's go to, and the next topic would be STEM extension people making mistakes only. We're seeing a lot of denials in the STEM extension. In the STEM extension, we see that that people are applying before 92 days. Emily, when the STEM extension, when the OPT is expiring, they are supposed to file the STEM extension within 90 days, not before 90 days. Some people try to go very near to the edge. I'm going to file on 89th day and or 85th day, and they're going to receive it on 90th day. Don't do that. If the USCIS receives your application before 90 days, they are going to reject that one. And they're going to reject, by the time they reject it, you won't have time to refile the application. Also, that once the DSO has issued an I-20, endorsed it for STEM extension, you have to file the STEM extension within 30 days, not after 30 days, though. It'll be rejected. So you have to be very careful in this thing. We also noticed that if STEM extension is only available for those people who have the who are in the STEM field. We are going to update the link. We don't have the link right now. There is the ICE website where you can go and check whether, what is that code called, Emily? I keep forgetting the name.
CIP code.
Yeah. Yeah, CIP code. It's with the DHS STEM designated degree program. I'm going to put out that in the chat, guys. If anybody wants to, you can take a look into it, though. I will also try to put out the web link later on, though. So your CIP code should match the one which is listed. If it doesn't match it, please contact your DSO and to contact an immigration lawyer. We are seeing a good number of STEM extensions denied because what USCIS is telling is that your degree is not a STEM degree. Hence, we are not going to give you STEM extension. That CIP code should match. Check with your DSO and check with the code, which I'm giving a link. If it's matching, that's fine. If it's not matching, you should contact your DSO and your immigration lawyer. Anything else, Emily, on that front from you?
No, and that CIP code is found on your I-20. That's the degree program. And you need to really be aware of what it is before you even graduate, because once you've graduated, you can't go back and change the code. So if you find out later that your SIP code is not on the list, then you don't qualify for a STEM extension. I've seen people that were told by an advisor at the school that, oh yeah, this is a STEM degree, you'll qualify. They went through the whole program, graduated, got their OPT, and then went to file their STEM extension and got a denial because USCIS said your degree program is not on the list, and it was not on the list. So that's something that you need to look at well before you're anywhere near graduation, because after you graduate, there's nothing that can be done. All right.
Perm
And last
process.
up is perm processing in 2024. What are the latest trends? Are we still seeing delays? What cases are being approved right now? When were those filed?
Perm processing, right now they're processing the cases filed in the December of 2022, not 23. That's approximately around almost 13 months, 14 months even up to. And some cases filed in January first week of 2023. They haven't come to second week of January of 2024 yet. So if you're planning to file a perm application though, I want you guys to file as I want, if you're in the first year of H-1B, try to file the application at that point of time, because we are seeing a lot of layoffs. So people have labor certification process might take 2 years. In that 2 years period, if you get laid off, the company is not going to continue with the labor certification. That means that you have to leave the country. So I want people, whoever got the H-1B recently, try to file the green card application as fast as possible. And if you are already in the 5th year, you already touched the 5th year, and your company is now starting the perm application, I definitely want you to contact an immigration lawyer. You need to have plan A, plan B, and maybe plan C. What happens if the labor certification is not approved by the time, I-140 is not approved by the time you complete the 6 years of the H-1B? Could you stay outside the country? Could you move on to the H-4 EAD option? Could you consider F1 option? Could you consider B2 options? All these things need to be sought out before you go. Please don't approach me when you are in 5 years, 11 months, and 25 days and come to me, find me a solution, Rahul. It's not going to be that easy at that point of time. If you come to me 1.5 years before, 2 years before, the solution may be much better. But if you come 10 days, 15 days before, I don't have a magic wand. Here's a magic wand. You get an extra 1 year. I don't think so we can do that. So please try to get these things resolved way before.
Yeah, and I would add, if the employer is not starting the process, or they're making you stay for a certain amount of time before they're willing to start the process, or you're in your 5th year and they're just now starting, where we know there's going to be a max out problem, start looking at the national interest waiver I-140 EB2. Those are the requirements, the criteria are much more open and accepted more than ever before. And if you can self-petition, you don't need your employer for that. So if you do that process, you get that I-140 approved, that allows you to extend your H-1B beyond the 6-year limit. Then the employer can take their sweet time and do the EB2 green card process through the Perm labor certification, or EB3, whatever it is. But consider NIW almost as a backup plan, or even a preventative measure to avoid that maxing out of the 6-year limit. And if you go ahead and do it on your own early, before your employer is even willing to start the process, your spouse who's on H-4 can get that H-4 EAD a whole lot faster. So I know a lot of people think, well, NIW is worthless because it's still EB2. It's not getting me the green card any faster, which is true. But it can help in situations where your employer is not sponsoring, or your employer delayed, or you just need to get your spouse work authorization faster.
Let's go to questions, Emily.
Sure.
Keval Raval has this question, emailed twice, didn't get the response. I'm extremely sorry about Keval. I did respond to you 6 days back. I remember that, but I didn't respond to your subsequent email, but I did it right now. Once I saw your message, I did respond to you for your email. Have we started seeing approvals of POM applications filed in February 2023? This comes from Pavan Kumar. No, we are only seeing the ones that were filed in December and January 1st week right now. Now, you need to understand, Pavan, though, if you have a POM application that was filed in February, though, assuming that your H-1B is expiring after February, after 1 year, though, you can file the extension based on the POM application. However, you will only get 1 year of H-1B extension. You won't get 3 years. You may want to consider if you're coming very nearby.
Srinivas says, I have my I-485 in EB2 and EB3 due to a refile. Can I apply for the EAD in both categories? Can you? Yes. Should you? Maybe not. You only need one EAD. All EADs have the same category. That's C9. That means you have a pending 485, whether it's your EB2 or EB3. I don't think anyone ever looks into that, and it doesn't matter. We have filed for both in the past, and many times, especially now that they're issuing the 5-year EAD, once the EAD is approved for based off of one category, when they get around to looking at the second one, they're going to say, we already gave you an EAD that's valid for 5 years, therefore you don't need this one, and we're going to deny or administratively close it. So it might not do you any good. I'm not sure what the benefit of applying for 2 EADs would be.
The company has hired international students for the first time, and they are willing to sponsor H-1B. Questions: how do you calculate the prevailing wage? It's better, Mr. Salil, to contact the immigration lawyer, though, because it is based on the geographical location, job duties, and these are all the things to be considered, though. Then we can go to the Department of Labor website, and that information is available. But it's based on the experience required and also the location, though. A lot of people ask the question, I have 20 years of experience. Does that my prevailing wage is going to be very high? No, it doesn't matter whether you have 10, 20, 50 years of experience. The question is, how much does the position require an experience, though? If the position requires experience of only 1 year, then the prevailing wage will be based on the 1 year experience. Not if you have 15 years experience, that's not how we calculate the prevailing wage.
P. Varma says, I currently have an H-1B from a cap-exempt employer, and they filed for my I-140. What are my options to move after the I-140 approval? Can I only move to a cap-exempt employer in the future? So number one, you, if possible, want to remain with the company for at least 180 days after your I-140 is approved. That way, if you then leave the company and they withdraw your I-140, it has no impact on your ability to use that I-140 to keep getting H-1B extensions beyond the 6-year limit, even with another employer, and it will not impact your spouse's ability to get the H-4 EAD or those extensions. So that's number one, stay for 6 months after the I-140 is approved if you can. Number two, you are subject to the cap. So right now, the only other employer you can work for is another cap exempt employer. If you want to work for a for-profit company, you have to go through the lottery in order to make that happen. So you need to start looking for employers now that would be willing to put you into the lottery in March of this year, so that perhaps in October, your I-140 will have been approved for 6 months and you can switch employers in October. Another thing, when you have a cap exempt H-1B, if you want to work for a for-profit employer concurrently, meaning you're going to do 2 jobs at the same time, a for-profit employer can file a concurrent H-1B to allow you to work for the nonprofit or the cap exempt employer and the for-profit employer at the same time without you having to go through the lottery. So that's another way to get that other employer, get the higher salary, work with a for-profit company while you're still, trying to get selected in the lottery one of these years.
Shiva, my AP is pending for several months. How to expedite it? One, you can go to Ombudsman office, but the chance of success is only 1 to 2% there. You can go to Congressman's office, that's only 1 to 2% there. You can call the USCIS, and if there's a real emergency, like death in the family or something like that, they may grant you an emergency parole that may be only valid for 1 month period. That the chance of success is about 5 to 6%. But at the same time, you can also take the USCIS to the federal court. Of course, this is the most expensive, but the results normally will not come through within 65 days. It takes more than 65 days to get a result. By the time you file it, the USCIS has the time to respond. It's 65 days. Don't expect that if we file a court case, boom, you get the approval. No, it will take 65 days now. So that probably most of the people use. If anybody wants to, they can contact Stephen Brown in our office. He's the one who takes care of the things.
Ghana has a question about the H-1B grace period. How does severance get counted in the grace period? It depends really on how it is showing up in your paycheck. So if you are continuing to get your normal paycheck and everything looks exactly the same and you get one extra paycheck, we've been able to successfully count the grace period from the end of that last pay period. But if your last paycheck says severance pay, or it's in some kind of different category than your normal salary to where that pay statement looks different in how everything is calculated, then I would not count the severance time in the 60-day grace period and go by the actual termination date.
Emily, have you heard of people are telling some AI rules have passed? We don't need labor certification anymore for the people who work in AI?
Well, I mean, you could get an NIW based on STEM, but no, none of the actual AI from that big announcement from the Biden administration. I don't think anything's really happened yet. I think they did put out a request for information for updating Schedule A to maybe add some STEM occupations there or AI occupations in there. But as of now, nothing has changed, except that maybe it's a little bit easier to get an NIW or an EB1A approved or an O1 approved based on these emerging technologies. Mahanti says, I recently returned from India, but my I-94 is not updated. Can this be corrected at the airport? So the better way to get it corrected, you need to contact Deferred Inspection. And there are a number of deferred inspection offices that actually have a special email address to handle I-94 corrections. Now, you can use any of those deferred inspection offices, even if that's not the airport you flew into. So I would find one that's closest to you that has an email address, email them first, see if they can do it without you having to go in to the office. And they usually are able to do that. They'll usually ask you to submit your passport copy, your flight itinerary, any other kind of proof to show that you traveled on that actual airline.
Pawan Kumar, what is the estimated time for Perm approval? Well, this first Perm filing time, Perm, people need to understand how much time does it take to file a Perm. Now, if you start from the scratch, that means there is no prevailing wage, though. It may take up to 1 year to just file the Perm. It's taking about 8 months to get a prevailing wage. Of course, lawyers will take their time, plus 8 months. Then there is a recruitment process. Now, sometimes things can be clubbed. For example, prevailing wage and recruitment process can be clubbed if your employer can work with your immigration lawyer very effectively. But typically, if you start from the scratch, anywhere between 8 months to 1 year is the time it takes to file. Once it's been filed, it's taking 13 to 14 months to get a Perm approval. Now, when does your priority date get established? Not when you file the prevailing wage, but when you actually file the Perm application, though. That's when the start of counting of the priority date, and that's what the counting of 1 year pending Perm also starts counting.
Clevy26 says, I applied for the H4 plus H4 EAD after being terminated from my job, and the application was set separately from the spouse's H-1B extension and amendment filing, so there's no premium option. Is there anything we can do to speed up the processing time? So you need to, number one, look to see if you qualify for any of the expedite criteria, if there's any humanitarian, if there's a healthcare. If you're working in healthcare field, that they have an expedite criteria for that. If that's not an option, then you're most likely looking at litigation again. We're back to where we were prior to the class action lawsuit, where we got the settlement agreement requiring them to process everything together. So we are doing some of those now to be able to get those. I think I saw an approval come through today for one that I filed in the exact same situation last July, just now came through. So that's definitely a long time to wait to be able to get back to work. And so litigation might be the route for that.
Sanjay Kumar is asking, can I freeze my H-1B for 3 years? And he can come back after the I-140 is approved. Absolutely. I mean, if you can go to India, and then if after the I-140 is approved, you can stay there for 3 years. You can come back at any point of time once the I-140 is approved on H-1B, of course. People are asking questions. Can I open LLC? Can my wife open LLC on H-4 EAD? Yes. And can she concurrently file for H-1B for me? That part I want you to discuss privately with an immigration lawyer, though. There is something black and there's something white, but in between there's a gray area. That's where we think you should discuss personally with an immigration lawyer, though. Yes, she can start an LLC on H-4, absolutely not a problem.
Srikant says he's on H-1B and his wife is on H-4 EAD, I-140 approved, but she lost her job. His wife is on H-4 and EAD and wants to know if she can apply for unemployment insurance benefits. So this question came up quite a bit during COVID and during all the layoffs and all of that. And yes, she actually does qualify because she has an unrestricted EAD. So if you as the H-1B holder lost your job, you don't qualify, but she as an H-4 EAD holder does. And that's not considered a public benefit for that whole 944 form, which I know that doesn't exist anymore, but the public charge rule is still there. But it's not considered a public benefit because you actually, as an employee and your employer, pay into it every month that you're working there. So you're just getting back what you paid into it.
Emily, Hari Guru has a question, and I want your opinion, I will give my opinion. I want you to correct, contradict, or whatever opinion you have on this one, though. He says that, can a new US government make more hurdles for the legal immigrants, like removing EAD and AP for the adjustment of status, taking out the H-4 EAD, delay in H-4 approvals? EAD and AP are considered to be interim benefits especially for those people for whom adjustment of status is pending. So I don't think so the new government can remove it. Now, can they delay it though? Yes, they can try to delay it by putting some or the other hurdles, but we immigration lawyers have learned our lessons though. Now, I've been an immigration lawyer for a long period of time, guys. I don't want to reveal my age, but I've been a long, long period of time. But then comes the Trump administration, and they started delaying the application so long. And we were trying to contact the USCIS. We were trying to contact the ombudsman. We were trying to contact the congressman. Nothing works out. We call, we tell, we even send the surgeons have appointments. Only this guy can do the surgery. USCIS didn't do anything on those things. And it was really sad for us. We immigration lawyers have learned, hey, let's start going to the federal court. And guess what? We got good results there when the USCIS started delaying. And we have some class action suits. We've been successful in those things too, to bring down the timing. So we started going to the federal court, and the courts did not like what the administration did. Now, more people are trained in the litigation. And let me tell you one thing. I've been practicing from 1997. I've never gone to the federal court litigating on immigration matters. We use some outside lawyers to do that. But somewhere in 2018 or 19, we started going to the court. In 2020, I took on my name thousands of people to the court. And we have been, there's no guarantee of success just because we were successful before, but I'm just telling thousands of people I've took with my own name as a lawyer. We have learned that if they try to delay, we can shoot them down. And we can not shoot them down. What I mean is that take it in the court and win in the court. Then comes with regards to, can they remove the H-4 EAD kind of thing? Is it easier though? My opinion is that once the EAD has been issued though, it's very hard for the administration to do it. They tried to take the Dreamers EAD. They tried to delay the H-4 EAD, but your comments, Emily.
Yeah, so I think because it is Tory, they can't just unilaterally stop issuing them. They have to go through the proper regulatory process to rescind the H-4 EAD regulation. Trump actually tried. They started that process. It was published in the Federal Register saying that it was on the agenda, on the unified agenda, which they put out every spring and every fall. It stayed there for quite some time, never moved forward. So it created a lot of fear. but they never actually issued a proposed regulation. So when the Biden administration came in, they just took it off the agenda. And then we knew from that point that the Biden administration had no plans to eliminate it. But yeah, another administration could come and try the regulatory process. It's not an easy process to get through. You know, if you just look at the fee regulation that we talked about at the beginning, that's been going on since 2016. We're now in 2024. So it's not an easy thing to get a regulation to go through. So I'm not overly concerned about it, but yeah, if we get, you know, another Trump or Trump again, we could see another proposed regulation to eliminate it. Peter Smith says, my 485 was submitted over a year ago. It's been stuck in the case remains pending due to retrogression, but now it became current in January and is still current in February. So I'm assuming the final action date is current. So he wants to know, what can I do? You know, you can try to reach out to your congressman or senator, but probably the best thing that's most effective is litigation, filing a lawsuit in federal district court for the delay to get that 485 approved. There are some bad precedents out there from certain courts and certain districts. And so you really have to be very strategic about filing a lawsuit for a 485 delay, but it can be done.
Neeraj has this question, and I've seen a lot of other people are also asking the question. Can the main applicant for the employment-based immigration be unemployed? It's not a clear answer, guys. Now, the rule says that you must have a job offer, continuous job offer, for you to get the green card once you file the 485 application. Now, if you are not employed, what does that mean? Could it mean that you don't have a job offer? It could be. It could be implemented. The officer can implement that you don't have a job offer and can deny the 485 application. Could it be that you got a job offer and then you really have been working for 10 years? You want to take a break for 6 months before joining from company A to company B? I would suggest you don't take a break though. But if you really want to take a break in those 6 months having a job offer, you may want to consult an immigration lawyer, assess the risk that is there. What are the probabilities of it based on all the calculations? And then seek to see if you want to be just sitting at home taking rest. That one possibility. People can be self-employed. There are very slight risks in it, but you can be self-employed in the same profession. You can have your spouse open a company and employ you. So that could be possible too. So you can consider all these options instead of just not having a job offer and then going to the immigration interview, or the USCIS finds that you don't have a job, they may just straightly deny the 485 application. So all these three options, that having a job offer with a different company, having a self-employment, or having your spouse employ you, all these things are a little bit riskier, but you should consider them rather than being unemployed. So anybody, this is only speaking about the main applicant, guys. The dependent applicant, it doesn't matter. They are unemployed. They're working as an immigration lawyer. They're working as a Pizza Hut delivery guy, which I did both of those things when I was a dependent 485 EAD. Nothing wrong with it. They can be unemployed, delivering the pizza, working volunteer, or working as an immigration lawyer. All these things are possible for the dependent. The main applicant has to be in the similar profession until they get the green card. Question on the H-4 EAD. My wife was employed until recently, and she is not employed right now. Can she file for unemployment benefits? Now, this is a surprising answer.
The H-4 EAD, I already answered that one.
Oh, you already answered. That's fine. Thank you.
But we do have more breaking news. I feel like it's a Friday because usually these breaking things only come out on Fridays. But USCIS has just announced the new lottery system. They've announced the online filing window for fiscal year 2025. And it is going to be the beneficiary-centric rule. That means one person gets one entry regardless of how many job offers. It takes effect 30 days from now, which means it will be effective for this year's lottery. The CAP registration window is going to open March 6th, 2024 and run through March 22nd, 2024. And they are going to use the new organizational accounts. So we're not using my USCIS accounts anymore. It will be upgraded when we log in. And they did also confirm that the registration fee will remain $10 for this year.
Okay, that's a good news. I think so. After our live session is over, though, Emily, can we do a session on that, on that topic? Okay.
Yeah.
Ooh, that's a big news, Emily. Let's go through the questions. And in the meantime, we'll have time to review it, and we'll do the session at 6:10 Central Time as soon as we're done.
So let's see. Question.
Sorry, go ahead.
Question from Yen. Can you give more information about STEM? DOL is considering adding STEM occupations to Schedule A, which means the Perm process would not be needed. Can my spouse work on the H-4 while waiting for a Perm approval for more than 1 year? So Schedule A is kind of a shortcut where the Department of Labor has already predetermined that certain occupations have a shortage of U.S. workers. Therefore, you don't need to go through the labor certification process, because the whole purpose of the labor certification is to determine whether there is a shortage of U.S. workers. So right now, Schedule A has nurses and physical therapists, that they already are shortage occupation. So you skip the labor certification and go straight to filing the I-140 petition, but it still is in either EB2 or EB3. So it's not a special category of the green card. It's just allowing the labor certification to be pre-certified. On top of that, it also requires a prevailing wage. So right now, although you don't have to go through the labor certification process, an employer does have to get a prevailing wage first and then post the notice of filing, and then they can actually file that I-140. So what they're wanting to do or considering as part of the Biden administration STEM push is to expand the occupations that qualify for Schedule A into some potential STEM occupations and say, hey, these certain occupations are considered shortage occupations, so you don't have to go through the labor certification process. So it kind of makes it more like an NIW petition without having to prove that the job is in the national interest. It's already decided that we don't have enough of these U.S. workers, and that's why a company can sponsor a foreign worker instead.
Why are we giving clues to the new government? Oh, believe me, there are some villainous people that are there that have they have a lot of money and they are already there. And if you want to, I will give you their website. Go look at their website. That is called FAIR Organization, FAIR. I think so. It's FAIR.org if I'm not mistaken. They are the funders of the, I'm hoping still Biden government is the new government, but if it's not, this other government is definitely supported by the Trump administration. This particular FAIR.org supports the Trump administration.
Visu says, can my GC process be started if I'm outside the U.S.? Yes, actually. There's no requirement for filing either a labor certification or an I-140 for anyone to be in the U.S. Same thing with family-based for filing an I-130. What you need to be in the U.S. for is to file adjustment of status. Otherwise, if you're out of the U.S., you would consular process. So you can go through the entire process while you stay outside the U.S. and come into the U.S. with a green card. Now, your employer's got to be willing to do that, willing to go through that whole process without you being here in the U.S. working for them. But yes, it absolutely can be done. Suda says, is there a way to get the H-1B approval notice copy quickly? It was approved a year ago and we never received it. The lawyer said it can take 30 days. Not really. So the way USCIS wants you to get it is to file an I-824 application for a duplicate approval with a $460 some odd filing fee, and the current processing time for that is supposedly 17 months. So it's certainly not fast, even though all they have to do is hit the print button and remail it. They are a little bit faster than that. The last one I filed took maybe more like 4 to 6 months. But you may want to consider a Freedom of Information Act request. In a FOIA, you can at least get documentation, and we've had some success in getting the actual approval notice from the file doing that. And that can still take a few weeks, but faster than the I-824.
Sudha Yanabadra has this question. Can we make an InfoPass appointment for urgent EAD? Very unlikely that they're going to grant you the EAD. If you are on adjustment of status EAD, if you're a medical, there are some ways where you can go to court, but that will take about 60+ days. But you need to consider if by calling the USCIS, you may be able to, by going to court, you have a 1 to 3% chance of success.
Priya says, my H-4 EAD card was lost by USPS. They confirmed after investigation that it was USPS that lost it. But now USCIS came back and said we have to file it again, even though it was USPS mistake. Are there any other options to get a replacement? No, you've got to file it again because the only time USCIS will send it again is if they actually received it back. And because it's lost, they didn't receive it back. So there's nothing that they will do. You can file it again and then perhaps litigation to get it faster, but you definitely need to file it like yesterday.
Paul Allen has this question. Can I change to F1 while I'm in US and B1, B2? Absolutely, you can. You can change within United States, no problem. You have to file a change of status. It's called I-539 application. Visu is asking a question. Can he file the green card Perm process while he's outside the country? And what part of the things that he has to be inside the country, though? There are 3 parts normally. One is called Perm labor. You don't have to be in the country. I-140, you don't have to be in the country. There is called consular processing. Now, this is where it's also called as 485 or consular processing, though. It's either or. If you do the consular processing, you can stay in your home country. You can get the green card in the consulate. After Perm, I-140, green card in the consulate, and you can fly into United States as a green card holder. That option is available for you. The third option could be done in US also. It's normally better to get it in US, but it's not absolutely needed. So technically speaking, for a person of the employment base, can they get the green card directly in their home country and come here? Absolutely, you can. Now, depending on the priority date, which category you are, the timelines are different, but legally it is possible for you to get the green card outside the country.
Manoj says, I'm on H-4, got my H-1B selected last year, and while the case was pending, had to travel to India due to an emergency and came back with H-4. Now my H-1B is approved. Can I work immediately? No. If you traveled while your change of status from H-4 to H-1B was pending, if you exited the country during that time, the change of status should have been abandoned. It happens automatically. So even if your H-1B was approved with the change of status and the new I-94, it is an error, and it should have been only approved for consular processing. You may need to consider travel to get the H-1B effective, or possibly refiling the change of status from H-4 to H-1B. Syed says, will there be any Perm processing time improvements now that we are filing in the flag system that started last year in June? I don't think so. I think things are going to get worse because that form is kind of crazy, and there's been no training given to DOL officers yet on how to adjudicate that form. So 6 months from now, I think we're going to start to see really weird denials that we've never seen before. And we'll have to go through motions to reconsider, motions to reopen, and all of that mess. That's going to clog up the system even worse. So I don't think things are going to get better just because of that flag system.
Midun, if the H-1B lottery gets picked up, can I raise my initial LCA with home address? It's not you can, but the employer can use the home address. Absolutely, they can. If you're working from home, can they use LCA as your home address? Absolutely. We normally feel more defensive when we put employer's address and home address. But if you're going to be completely working home, you're not going to go to work. I mean, once in a year, that's not considered to be working home. So you can use a LCA address. Okay.
Vijay says, can my employer apply for the LCA before 6 months of my H-1B extension expiration? So the LCA cannot be submitted more than 180 days before the start date being requested on the H-1B petition. So if you're, we're in January 30th now, if your H-1B is expiring in October, that's more than 6 months from now, it is impossible to submit an LCA asking for an October start date. But what your employer can do is submit an LCA with a start date 6 months from now, and request an H-1B extension early using that LCA that's got an earlier start date on it.
What is the projected EB1 priority date? Definitely it's not going to be current, but it's going to be a slow movement in EB1. How long does the consular processing for the green card takes versus the 485 application in USA? Assuming the priority date is current, though, from the time that the process started, it may take anywhere between 1.5 years to 2 years for people to get the green card in the consular processing. Now, of course, 485 application is going to take the same time, but it's more easier if you are in USA to process the 485 application than compared to when you are outside the country. It's more easier, but it's not, it will take 1.5 to 2 years for you to get the green card. Anything else, Emily? We're going to go to live session on the H-1B. That seems to be most of the questions coming in.
Yeah, I think we can wrap up for today. Thanks everyone for joining us with all this breaking news. As usual, we'll be back next Tuesday with the updates and to answer your questions. And you can join us. We're going to go live again on the H-1B lottery regulation that just came out. So stay tuned for that if you'd like to find out.
Yeah, within 10 minutes, we'll be live on H1 after reading the regulations. Thank you, bye. Thank you, guys. And if you want to consult me or Emily or anybody else in our office, our appointments are open, our schedule is open. You can go to the link and make an appointment at any time. Thank you guys for coming in.